Hello, everyone. Welcome to today's program, Post-Acquisition Disputes, Basics and Strategy. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association. And today I'm delighted to introduce our speakers, Christina Fung and Peter Brown. Christina is a certified public accountant, accredited in business valuations, a certified fraud examiner, and a certified anti-money laundering specialist. As a member of GHJ's forensic services practice, she provides litigation support, including expert witness testimony, complete forensic and fraud investigations, and supports clients with issues that may threaten their business. She was named Young Accountant of the Year at the International Accounting Awards in London, one of the top 100 CPAs in Los Angeles County by the Los Angeles Business Journal, and received the AICPA's Standing Ovation Award, which is awarded to professionals in forensic accounting or business valuations who exhibit exemplary professional achievement. Peter is also a certified public accountant, accredited in business valuations, a certified fraud examiner, and certified money laundering specialist. He is the forensic services practice leader at GHJ with extensive experience quantifying damages in commercial litigation and conducting internal investigations. He has served as an expert witness and as a third-party neutral accountant in financial matters and purchase disputes. Prior to GHJ, Peter spent 30 years at Big Four accounting firms. He is an active AICPA member and currently serves as CalCPA's statewide counsel, having previously chaired CalCPA's forensic service section. We can't wait to hear what these experts have to share with us today, so I'm going to turn it over to them.
Well,
Thank you
great.
very much.
Thank you very much for that warm introduction, and thank you to the Beverly Hills Bar Association for having us today. As mentioned, I'm Peter Brown. I'm a partner with GHJ, and GHJ Greenhouse and Jenks is an accounting firm, full service accounting firm located here in Los Angeles, and I'm going to be speaking to you today about post-acquisition disputes. So today's topic really is very interesting because it's really the intersection between accounting, deal making, and litigation. So many attorneys, and I assume those on the call, are involved in negotiating deals and buying and selling of companies, conducting diligence and closing transactions. But as many of you know, after the closing is when the disputes begin. So the issues we're going to be discussing today can sometimes result in millions or tens of millions of dollars in damages. And that those occur really after the transaction has already closed. So we'll talk about the types of disputes that arise, the contractual language that is often more important than the accounting language in the agreements, and then how forensic accountants become involved. But before we do that, I'll just allow my colleague, esteemed colleague, Christina, to just give a brief introduction of herself as well.
Yes, thank you, Peter. Hello, everyone. My name is Christina Fung. I'm a principal with GHJ. It is my pleasure to address the Beverly Hills Bar Association today. As Peter mentioned, we've worked on many post-acquisition disputes, and we're excited to bring this topic to you. Let's take a look at the agenda. This will be our roadmap for the next hour. We'll begin with the major categories of post-acquisition disputes. Next, we'll discuss how contractual language often drives outcomes in these cases. We'll then examine the role forensic accountants play before and after closing. And then finally, we'll be walking through several case studies illustrating how these disputes unfold in practice. By the end of today's program, our goal is for you to be able to spot potential dispute areas earlier and understand where accounting experts can add value. So, Peter, I'll throw it back to you. Let's get started.
Well, thank you. Okay, so let's go to the next slide. Let's just introduce the topics. Typically there's really three different types of disputes that we talk about when we have a post-acquisition dispute. The first is a networking capital true-up, and we'll define and explain what that is. The next is an earn-out dispute, and the last category would be representations and warranties disputes. And the common drivers for those really are, ambiguous, vague, or omitted contractual provisions. I bet if I was to do a poll of the attorneys on the call, and I asked how many of you actually enjoyed taking accounting classes or actually have taken accounting classes, I would suspect there's a pretty small number of people on the phone, and it's because lawyers typically don't do the accounting. They don't do accounting for a very specific reason, because they want to pursue other things. And when you have accounting provisions that are within a contractual document, sometimes it leads to problems. The other issue is sometimes there's accounting differences. So you have the difference between historical practices and what we call generally accepted accounting principles, or GAAP. And then the other issue, which is really sometimes at the core, is there's misaligned incentives between what the buyer expects and what the seller expects. So let's first talk about net working capital. The next slide. So what is net working capital? What is working capital? And I suspect there's some folks on the phone that don't know what working capital is. Well, working capital from an accounting perspective is current assets minus current liabilities. And what's that, right? Well, I like to think of working capital as breathing room. So let's assume you have a small business and you need to make payroll this Friday, right? Do you have enough cash in the bank to make your payroll? Well, to me, if the answer is yes, let's say you have oodles of cash, that's great. That means you probably have sufficient working capital to pay your debts as they come due. But if no, then you are deficient in working capital. And so what we define current assets as is things that you own that will turn to cash in the current year. So think of things like cash. Cash is cash, obviously. Accounts receivable. Hopefully, your customers will pay you within a year. Um, Inventory. Let's assume you have inventory. Well, hopefully you will turn that to cash within a year. And then you subtract from that the liabilities, which typically would be things that you owe, such as accounts payable. Think of things like payroll, mortgage payments, rent, insurance that comes due. These are all things that you pay in the normal course. So the things you have available, the current assets minus your current liabilities, is working capital. Now, what happens when a company is sold typically is that's kind of a nebulous number. And so companies typically will be sold based on a target or a peg. So we think the working capital as of the date of the deal is going to be X. But that's kind of a difficult number to get out, to get at because the business is operating. I mean, if you got an ongoing business, your working capital is really changing every day, right? So it's a difficult number to get at, particularly if you're operating. So they set a peg, and it can be a very specific number. I've got a number here. This is for a deal we're actually currently working on. The peg is $13,060,103.48. That is actually the number that is in the agreement between the parties. And what happens is there's typically an initial target amount that's put in the deal. And then after the buyer takes control of the company, there will be a final audit or a final true up of working capital. Typically, financial advisors or auditors will come in and they will audit the balance sheet as of a very specific date, the date of the deal, and they will put the working capital at a certain number. And there's typically a dollar for dollar difference. So if the peg was 13,060,000 XXX and the actual working capital comes in as of that date, there will be a dollar for dollar difference between the purchase price and what the seller and the buyer agree to. And that either results in the seller receiving more money or the seller returning funds back to the buyer. And a lot of times there'll be like escrow funds that are held aside in order to make sure that the true up occurs. So disputes arise because what happens is, and a lot of times we see this, is that the contracts between the buyer and the seller, the deal document, is ambiguous. It's vague, or sometimes key definitions are missing. And again, these were agreements written by non-accountants, and it's difficult sometimes for the accountants to figure out what was actually going on, and disputes arise. There's also differences between how the company was operated. And just think of a company that was a small business. The founder of the company is getting to the point where they want to make a transaction, maybe for estate planning purposes, et cetera. So they ran the company a certain way, and they accounted for things a certain way. And then what happens is you have a buyer comes in, and then the buyer runs the business differently. The buyer has different accounting policies, has different ways of looking at things. And those differences can give rise to differences in the working capital. Things such as the inventory. How do you value inventory? How do you determine what accounts receivable are collectible and what needs to be written off? Well, those require judgments. So there's a lot of judgments that are made by the buyer when they come in, and those judgments do impact working capital as well. And so that sometimes you get disputes that arise as a part of that. And what happens is a lot of times in these agreements, if there's a dispute regarding the working capital, that dispute will not be heard by a lawyer or a judge. That dispute will typically be heard by a neutral accountant. And I've actually served in this role dozens of times myself, and I also do a lot of party appointed work where I represent either the buyer or the seller in a transaction. So let's go to the next slide. The next type of dispute that typically arises is what we call an earnout. So imagine a company that is sold. I have a company right now that we're working with where the company was sold for roughly $100 million. But the sellers thought that the company was worth more than that. Sellers think the company is worth more like $150 million. Well, in order to get the deal done, the sellers agreed to an earnout, which means that they'll get a certain amount of money up front, and then they may get some additional compensation contingent upon certain post-deal performance, which can be earnings, and we'll see there on the slide EBITDA. Let's define EBITDA. EBITDA is earnings before interest, taxes, depreciation, and amortization. Some people think that that looks a lot like cash flow, but you could do a deal based on revenue or some other financial metrics as well. So typically there would be another peg, another target. Let's assume the earnings of the company are supposed to be X. If the earnings come in higher than X, then the sellers will get some additional compensation. That's typically how it works. Earnouts are also used typically for when you want the seller to stick around. So let's assume you have a founder who has a lot of great relationships, has key customers that they handle, et cetera, a lot of business knowledge, and you want the sellers to actually stick around after you buy the company. Well, a way to incentivize them to stick around was to put in an earnout as well. And so we have issues that come up because we have conflicts that arise. Because what happens is the buyer takes control of the company after the company's sold, and the buyer runs the business the way the buyer wants to run the business. And sometimes that's to the detriment of the person who has the earnout, because the person with the earnout wants everything to be done in a way that's going to maximize their earnout. The buyer may have different ideas, and so that you can see where sometimes that could lead to disputes, and it's very common as well. Let's go to the next one. So the last area where we really get involved in these post-acquisition disputes is in representations and warranty disputes. And so this is a situation, if you guys have seen these deal documents, you'll see that there's a section of the document that says the seller's representation. So the seller represents a bunch of stuff. Financial statements were prepared in accordance with GAAP. We've disclosed our liabilities to you. We've represented we complied with laws, environmental, et cetera. So they represent a bunch of stuff. And then the buyer actually represents a bunch of things as well. And there can be disagreements post-close involving those representations. A lot of times it has to do with the accounting. Because again, if you had a business that was accounting for certain things a certain way before the deal, and now the buyer comes in and changes things and thinks the way that they are doing it is correct, well, then they say, well, wait a minute, seller, you violated your representations because you weren't doing it right. And so these are the things that come up. There's tax issues that come up. There's environmental, and I think we probably have some environmental lawyers on the line. I mean, that's a whole nother area of the law, environmental law, right? And then you have legal disputes. Hey, we just got a subpoena that showed up as seller. You didn't tell us about this lawsuit. Those types of things can lead to disputes regarding representations and warranties. And it's interesting because there are insurance carriers now that provide insurance for this. And it's difficult for them it's difficult for the parties to get a claim paid. I don't believe I've ever seen a situation where the carrier did not at least deny the claim initially, saying, no, we're not going to cover that, right? But if you continue to fight, sometimes you can get some coverage. So those are really the main areas that we talk about when we're talking about post-acquisition disputes. It would be working capital number one, earnout, and then reps and warranties disputes. Let's go to the next slide. So now I'm going to turn it over to Christina, who's really going to talk to you about contractual language.
Okay, thank you, Peter. Great, let's go to the next slide. Perfect. Okay, so let's talk a little bit about how contract language can drive the outcome in these matters. One of the most important themes we'll discuss today is that courts generally do not resolve these types of disputes by asking, what is the best accounting answer? Instead, they're going to ask, what did the parties agree to in the contract? And that's a critical distinction. Attorneys sometimes assume that if an accounting issue arises after closing, the answer will be found somewhere in GAAP. But in practice, GAAP is often secondary to the language that the parties negotiated. If a purchase agreement contains a defined term for EBITDA, working capital, revenue, or debt-like items, courts and arbitrators will typically start there and often end there. We've seen situations where both parties' accounting experts agreed on the technical accounting treatment, but the outcome was still driven entirely by how a term was defined in the agreement. And when the agreement is silent or unclear or ambiguous, that's when things become more complicated. In those situations, judges, arbitrators, and neutral accountants will frequently turn to contemporaneous evidence to determine what was the intent. So that might include things like diligence materials, draft agreements, management presentations, emails exchanged during negotiations, text messages, quality of earnings reports, or other board materials. In other words, accounting records stop being just financial information, they become evidence. And that's one of the reasons forensic accountants become so heavily involved in these disputes, because we're often helping reconstruct not only what happened financially, but also what the parties understood and intended at the time of the transaction. So let's go to the next slide, please. And we'll talk about some key areas where language matters. Okay, so looking at some specific areas where contractual language frequently determines the outcome. The first is the definition of financial metrics. Most disputes involve terms that sound simple on the surface, right? Like Peter has already discussed some of them: working capital, EBITDA, net debt, cash, debt-like items. But then once you start unpacking those terms, dozens of questions can emerge, like, should deferred revenue be included? How are customer deposits treated? What about accrued bonuses? What about reserves? The level of specificity in the definition can dramatically impact the dispute risk. The second area is one that we've already touched on a little bit: GAAP versus consistency with historical or past practice. This is probably one of the most common sources of post-acquisition disputes, because the buyer often wants financial information prepared in accordance with GAAP, and the seller often wants calculations that were performed consistently with their historical practice. And those concepts may sound compatible, but they aren't always. Because what happens if the seller's historical practice wasn't technically GAAP compliant? Which standard controls? Peter and I have seen agreements that say calculations must be prepared in accordance with GAAP, applied consistently with past practice. Because that sounds reasonable until GAAP and past practice point in two different directions. Then you've essentially built a dispute into the agreement. Another critical area is dispute resolution provisions. Many attorneys focus heavily on substantive provisions and devote less attention to the dispute mechanics. But those provisions can significantly impact the outcome as well. For instance, will the disputes be resolved in court? Are we going to do it in arbitration by a neutral accountant? Who will the neutral accountant be? What issues can the neutral decide? Like, can the neutral interpret the contract, or can they only perform accounting calculations? All of these distinctions matter enormously, and they can have a significant impact on the outcome. The next area is earnout operational covenants. As Peter discussed earlier, once the transaction closes, the buyer typically controls the business. And if the seller's future compensation depends on performance metrics, the agreement should address how the business will be operated. Like, will the buyer be required to act in good faith? Do the operations have to be substantially consistent with the activity before the transaction closed? Can certain expenses be allocated differently? Can key employees be terminated? When those provisions are absent or they're vague, disputes can become much more likely. And then finally, we have indemnification provisions and reps and warranties. The structure of caps, baskets, survival periods, and fraud carve-outs can completely change the economics of a dispute. Even where liability appears limited, allegations of fraud may allow the parties to bypass contractual protections entirely. For the litigators in the room, you've probably seen cases where the fraud allegations become just as important as the underlying accounting issues. And let's go ahead and go to the next slide, please. We'll talk a little bit about practical implications. Okay, so what does this all mean in practice? The good news is that many disputes are preventable with careful drafting. Clear drafting can eliminate ambiguity before it ever becomes a problem. One of the best tools available is the use of examples and sample calculations. If the agreement contains a sample working capital calculation, a sample EBITDA calculation, or illustrative schedules showing how certain items should be treated, it becomes much more difficult for the parties to argue later about intent. When agreements are vague, disputes tend to shift away from accounting and toward interpretation. And interpretation battles are expensive, right? Because now we're hiring attorneys, we're hiring experts, we're exchanging expert reports, we're conducting discovery, we're taking depositions, all because two parties had different understandings of a few sentences written years earlier. There's this joke out there that forensic accountants are often beneficiaries of poor drafting. The more ambiguity exists, the more work there is for experts to do. And from the client's perspective, ambiguity can be expensive and also avoidable. So the clearer the agreement, the lower the likelihood that experts like Peter and I will need to become involved later. Okay, and let's go to the next slide, please.
Well, hold on, before we go to the next slide,
sorry.
can we go back?
Go ahead.
Can we go back up? I just want to spend a couple minutes here. My experience working with these agreements is it may have an arbitration provision in there where if there's a post-acquisition dispute involving, let's say, working capital earnout or earnout, it will be heard by a neutral accountant. Okay, so that's where I come in sometimes and will serve as a neutral accountant or will serve as a party appointed. But one of the things that's never addressed in these agreements is discovery, right? So if you have a dispute that's going to be heard by a neutral accountant, what do you do about discovery? What do you do about depositions? What do you do about normal interrogatories or the normal process of going through discovery? What happens a lot of times is the business gets sold, the buyer is in control of the business, the seller is now the out party. They no longer have access to records, to people, etc. And then there's a dispute. Well, the seller needs access to information in order to make their case, but the agreement is totally silent on discovery. And that's not unusual. That's pretty much the rule. And so a lot of times you'll see the neutral accountants be asked to essentially serve as discovery referees. And this happens all the time. And so I agree. The other thing I didn't want to pass over too much is the issue of putting an illustrative example into your deal document. So just put it as an exhibit that says, this is how we're going to calculate working capital, because there's a standard definition out there for working capital. But guess what? I've seen so many different definitions of working capital throughout my career. Just put something in the agreement that talks about what things are in and, more importantly, what things are out and how things should be calculated. I think that really does go a long way in minimizing potential disputes later. So let's go to the next one. So let's really talk about the role of forensic accountants and go to the next slide, please. So early involvement, I'm going to talk about quality of earnings or getting financial advisors involved here in the next slide or two. But there's an opportunity to get involved pre-deal, and I really do encourage particularly the sellers to do that, to really spend some time getting their company ready for sale. And so you could bring in financial advisors before the deal to do things such as look at the financials, look at how your financial statements are being prepared. Do you see any red flags associated with that? And then normally where I come in would be, and Christina comes in, is in the post-acquisition dispute world, where we're really being asked at that point to analyze the financial information, provide really independent expert opinions. So we will actually be drafting, let's say, an expert report to support our client's position in an arbitration. We will assist if asked. We'll go to mediation. We'll help try to settle the case with the parties. We'll be asked a lot of times to quantify damages that are associated. Sometimes there's out-of-pocket damages. Sometimes there's delay damages. Sometimes there's other damages that arise. and we really assist in the resolution. And also, as I said, a lot of times we are actually asked to serve as the neutral or, the judge, jury, and I like to say executioner in the matter. So let's go to the next slide and talk about quality of earnings. So quality of earnings, you may have heard this term. It's kind of an industry in of itself, but it's really sort of the kick the tires before the deal is done. And so the seller gets the opportunity to do that, and the buyer gets the opportunity to do that. And if you take my advice, if you're a seller, you're looking to sell the company, get your quality of earnings people or your financial advisors in early, because a lot of times they're going to make recommendations what you should do to clean the business up, let's say, get it ready for sale. And I'm talking really more in an accounting perspective as opposed to other things. How are the financial statements being prepared? How are you accounting for certain items? Make sure you're doing those in a way that's going to be, attractive to potential buyers. If you're not doing things in accordance with GAAP, well, go ahead and make some accounting changes so you are in accordance with GAAP. But then it takes some time, right, to have those things flow through the business and to get, things back up and running, get things normalized, let's say, before the buyer comes in or potential buyers come in. So I would say on Q of E side for sell side, and our firm does a lot of sell side deals, get in early. I mean, 2 years is not too early to get in and try to get a business ready for sale. A lot of times we get calls, hey, we want to sell our company next month. Can you come in and help us? Well, that's really too late. You can't really do too much. You need to give yourself 6 months to a year at least to get the business ready for sale. But some of the things we do is, normalize EBITDA. So EBITDA, again, would be earnings of the company. Remove non-recurring items, right? Or what we say, owner compensation related things. If, the business owns 3 delivery trucks, 2 forklifts, a Lamborghini, a Porsche, and a Mercedes. Well, wait a minute. Let's go back. What about the Lamborghini, the Porsche, and the Mercedes? Those things are really not business assets. Those are things that the owner is just kind of flowing through the business. So let's get those things off the books, right, before we sell the business. And there's a whole bunch of other stuff in there that relates to really owner comp that you want to take out, normalize the earnings of the company before you put the company up for sale. So that's Q of E. Let's go to the next slide. The next one would be, valuation gap. So we're talking about a valuation gap is just how do you adjust for informal financial metrics? So, the buyer is going to assume some risk here, right? And I think that forensic accountants can help in kind of identifying what those things are. So the buyer comes in and does their own Q of E, and then they're going to identify certain things. And it's like, the seller doesn't account for inventory properly. We recommend that the seller or the buyer do a full physical count of inventory before the deal happens, et cetera. So really, it's trying to get these valuation of certain key assets, make sure that there's commonality between the seller and the buyer on valuation type issues. Let's go to the next slide. And this is, I think, you're going to take this one, right, Christina?
Yep, exactly. Okay. So let's talk a little bit about the data room and due diligence readiness, right? So I think when most people hear the phrase data room, the reaction, there's like a mix between excitement, mild anxiety, fear, just depending on where you're at emotionally. Forensic accountants tend to feel the same way. Virtually these days, every transaction involves some form of a centralized electronic repository containing financial records, contracts, operational information, and diligence materials. So a well-organized data room does more than just facilitate diligence. It also helps establish credibility and build trust. Because if the information is complete, it's reconciled, it's readily accessible, it's organized, the buyer gains confidence in the quality of management's financial reporting. On the flip side, disorganized records tend to raise more questions, like if there's missing schedules, unexplained adjustments, multiple versions of the same financial document, or inconsistent reports. Those issues don't necessarily indicate fraud or misconduct, but they often create additional diligence scrutiny. So one practical observation that Peter and I have seen repeatedly is that disputes often arise not because information was hidden, but because the information was poorly organized or difficult to understand. Because the seller may believe disclosure occurred, and the buyer may believe it never received the information. And then years later, the parties are arguing about who knew what and when. Good documentation can prevent those arguments. So, and from a litigation perspective, a well-maintained data room often becomes an important source of evidence regarding disclosure and intent. So the point is, be organized, be prepared, be complete. Data rooms are important.
Okay, let's stop. Let's just stop there for one sec too. What about file names? I mean, how many times, I mean, if you guys have been involved in deals and you go into a data room and you get file names that make absolutely no sense, right? When you're talking about getting organized, name files that make sense. So when you're making a disclosure about certain things, if you're talking about working capital, maybe put working capital in the name of the file. You know what I'm saying? Do that, make it organized in a sense that someone who's really not connected to the deal, let's say, could go into the data room and make sense of how things are organized. That would really go a long way, frankly, in minimizing disputes later as well.
Amen, Peter. Okay, let's go to the next slide. We'll talk a little bit about fraud and financial misstatement risks. Okay, so another area where forensic accountants frequently become involved is evaluating allegations of fraud or financial misstatement. Many middle market businesses are founder-led organizations, and that's not inherently problematic. In fact, many highly successful companies are run that way. However, founder-led organizations sometimes have weaker internal controls than larger companies would. Responsibilities may be concentrated among a small group of individuals, or you might have a limited segregation of duties. Documentation may be informal or it may not exist at all. Adjustments could be made outside of the formal accounting processes. And these circumstances can all create risk. Importantly, risk does not necessarily mean fraud. One challenge that we see in post-acquisition disputes is that buyers occasionally discover accounting issues and immediately assume misconduct. But the reality is often more nuanced. Like a financial statement may contain errors without any fraudulent intent. A reserve may be understated because management was overly optimistic rather than being deceptive. Part of the forensic accountant's role is to distinguish between intentional manipulation, aggressive accounting, and simple mistakes. We use tools like analytical procedures, transaction testing, data analysis, and other techniques to evaluate whether the financial information appears reliable. And those analyses often become important evidence in both litigation and settlement discussions. So with that, I will turn it back to Peter and we'll talk about some case studies and real world examples.
Yep. So these are actual case studies that we've worked on. Go to the next slide. So the names have been changed or not here to protect the innocent. Here's one. And, normally I would put up here, these are all cases that we won. Well, the first one I'm presenting is a case that we lost. Okay. This is a situation where we represented the seller. Okay. And this was a seller that he was a brilliant guy. Him and his brother started a company, software company. They built a better mousetrap for a certain application. And then they sold it off to a much larger company. Okay. And they had a huge payday. It was wonderful. But a lot of the compensation for the sale of the company, in my opinion, way too much, was contingent upon an earnout. And so took a relatively small amount of money up front and then was hoping for a big payday on the back end. And what happened is this is a seller-led, founder-led company. They were not necessarily recognizing revenue in accordance with GAAP. So again, software company, if they got a software sale for $100,000, they would recognize $100,000 of revenue. Well, if you go to the GAAP associated with revenue recognition, well, GAAP says you can only recognize revenue when you meet certain performance criteria, parameters within the pronouncement itself. So you don't get to recognize $100,000 right up front, right? And so we have this issue where we have consistency of practice because the seller was thinking, well, yeah, for purposes of my earnout, I realize it wasn't GAAP. But we're going to be consistent because if we measure the performance of the company on an apples to apples basis, which would be before the deal and post deal, you got to measure it based on the way we used to measure revenue. Okay, so then there's a big dispute over that, right? So then a neutral accountant arbitrator gets appointed, and what happens? Well, the neutral accountant arbitrator says, well, wait a minute, your agreement says GAAP consistently applied. So I am going to say that gap controls and does not, and so you're the way you historically recognize revenue is not right, and so I'm going to rule against you with respect to your earnout, and that was worth millions of dollars in compensation to this person, and we felt horrible about it, but it was a situation where it wasn't the work that we did that ended up in causing the issue. The issue was the agreement, and the issue was there was some ambiguity with respect to the earnout and how it was going to be treated post closing, and so that was the issue there. So that's really the first that's the first example that we have.
So let's go to the next slide, and we'll talk about another case study, a real world example, which involves a net working capital dispute that Peter and I were involved in. So as we discussed earlier, working capital true-ups are intended to ensure that the buyer receives the business with a normalized level of working capital at closing. So in theory, that sounds like it should be fairly mechanical, but in practice, these disputes can become surprisingly complex. In this particular matter, the purchase agreement provided for a post-closing purchase price adjustment based on the difference between the balance sheet at closing and then a final audited balance sheet that would be prepared after the transaction closed. The challenge was that the agreement did not clearly define several key working capital components. They were just vague and ambiguous language. Like many disputes we see, the problem wasn't that the parties forgot to address working capital. The problem was that they thought that they had addressed it, but they left enough ambiguity for reasonable people to differ in terms of the conclusions that they reached. So after the acquisition closed, the buyer applied accounting policies that differed from the policies that the seller had used in historical practice. And so the disagreement centered around three primary areas. First, accounts receivable and bad debt reserves. The buyer believed that additional reserves should be recorded because certain receivables appeared less collectible than what had been historically reflected on the seller's books. The seller thought that, hey, the historical reserve methodology, we've been using it consistently for forever, for years, and it accurately reflected their collection experience in the past. The second issue was inventory valuation. So the buyer believed additional adjustments were necessary to account for slow-moving or obsolete items. The seller maintained that its historical inventory practices were appropriate and consistent with how the business had always been run. And then third, we have this issue of reserve account accruals. The buyer argued that certain liabilities and reserves were understated at closing and they should be increased. Seller disagreed. So as a result, what began as a purchase price adjustment exercise evolved into a dispute involving competing interpretations of accounting policies, historical practices, and contractual language. The matter was ultimately submitted to an arbitrator for resolution. And then in this case, the arbitrator focused on the specific accounting issues submitted by the parties and evaluated them within the framework established by the contract. And the results, it's essentially a split decision. The arbitrator agreed with the seller on certain issues, including aspects of the receivables and the inventory valuation disputes. But then the arbitrator agreed with the buyer on certain other issues, including the reserve account accruals. So neither side won everything, neither side lost everything. And frankly, that's a fairly common outcome in working capital disputes. It's rarely just like a total and complete victory for one side. From a forensic accounting perspective, both parties retained financial advisors to support their positions. The experts analyzed relevant accounts. They reconstructed the working capital calculation. They evaluated the historical accounting practices and prepared written submissions supporting their clients' views. I'd say for me, the key lesson from this case is that working capital disputes are rarely just math exercises. Like the numbers matter, but the outcome is often dependent on definitions, assumptions, and accounting methodologies that are embedded in that purchase agreement. And when those provisions are ambiguous, the true-up process can become really messy. And then we're dealing with this months or years after the deal is closed.
Yep. Let's go to the next one. And before we go to this last case example, I want to spend just a few minutes because it might be worthwhile to just discuss, what's our approach when I serve as a neutral accountant. What do I really try to get at? Because you have a situation where the agreement may be ambiguous, right? The agreement may be, there may just be, there's not even there. The issue that you need to address is not even covered by the agreement, right? Or it's vague and it's not really well defined. And so what happens in those situations? And what I tell the parties is, and these things are normally, when you arbitrate these things, they're normally done through 100% written submission. So each party will be able to submit their case to a neutral accountant, have an initial brief, and the brief will include basically anything you want to throw in there. I would say kitchen sink, anything you want. So can be obviously a brief written by the lawyers, can be an expert report written by your financial advisors, can be witness statements, can be accounting records, can be anything you want, photographs, whatever you want to do, throw it all in there to make your case. And if you've got a vague agreement, what I really like to look for is what are the contemporaneous documents, information that was available as of the time of the deal that really kind of set forth the parties' positions. What is the intent? What was the intent of the transaction? Now, the buyer's intent and the seller's intent may differ, but let's understand where each party was in the negotiation and what they were bargaining for. And that's really what I try to get at. And so if the parties don't produce the information I want to see, I will typically ask for that information. Typically, there'll be an initial submission, and then there typically is a reply or rebuttal submission, and then you'll get a decision that comes from the arbitrator. And that's how these things typically work. But if you've got an agreement that's not great, right, the more contemporaneous information you can come up with to support your position goes a long way in these types of disputes. And so this last case example that we have is a reps and warranties case that we're just worked on. And this is a situation where it appears that the buyer is trying to get two bites at the apple. So let's assume you have, in this case, you have a situation where you did have a working capital true up, okay? And as a result of the working capital true up, the seller actually had to pay the buyer a certain amount of money, a couple $1 million in post-closing working capital true up. So the working capital that the seller delivered was under what the target was, so they had to pay $2 million to the buyer. Okay, you would think that would be the end of the argument, but the buyer came back and said, no, 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 no. We still have arguments regarding inventory. So the seller's position was, well, wait a minute. We already discussed inventory. We already did a true up of inventory. Things such as, a book to physical adjustment, or, issues of obsolete inventory, or the level of the inventory reserve, et cetera, all these types of things related to inventory. You had your bite at the apple because you had your working capital. Why are you coming after us for reps and warranties violation? Well, they say, you had a non-GAAP way of accounting for inventory. Well, yes, that's true. We told you about that. Your Q of E that you engaged a Big Four accounting firm to do, told you that the inventory was accounted in a certain way that wasn't necessarily GAAP. So you had plenty of disclosure. This isn't fraud. And a lot of times, what you have to prove in these cases is you got to get over that hump of intent and get over that hump of fraud. And so the seller's arguing, yeah, there were problems, but number one, you had your bite at the apple, you had a working capital true up. So why are you complaining now about reps and warranties? And the buyer is saying, no, 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 no. If we would have known you had all these problems, we never would have bought the company. Result of that was that the outcome was that the court agreed with the sellers that there was sufficient disclosure regarding these non-cap issues, et cetera. And so that defeated the fraud claims. And they also agreed with the seller that the accounting inventories involved, et cetera, inventory and other things, that should have been covered in net working capital. So this was a win for the seller in this case.
Well, Peter, I'm sorry, I just noticed we had a question that came in through the Q&A function. It's actually good timing because we're talking about reps and warranties. The question was, what is a basket? What is a basket in reps and warranties?
What is a basket?
Yes.
Well, I mean, you're talking about a basket of either assets or liabilities. Is that what we're talking about?
Exactly. So let's just explain to them what a basket might be in this context.
Well, I mean, a basket would be, what a accumulation of, let's say, assets or accumulation of liabilities. That's what I would say a basket is.
Yeah, exactly. So just within the contract, there might be specific thresholds that are set out for certain buckets or items that go together, and it's considered they're bundled together into a basket. So there might be a specific dollar amount target that is set for certain baskets of items.
Yeah, so you might have, I mean, current assets may be a basket. So a basket would be cash, accounts receivable, and inventory. So that's a basket of current assets. Current liabilities might be accounts payable and other accruals. That could be a basket of current liabilities.
Exactly. And it's typically defined within the contract,
Yes,
right?
typically defined, but sometimes not. I mean, you might have an agreement that says current assets like current liabilities. I don't really like those types of agreements. If most people know that, current assets typically involve these things. Current liabilities typically involve these things. But let's just write out specifically. I mean, if you've got, 10 current asset accounts in your books and records, right? Just list them out, all 10 accounts. Current assets include these 10 accounts. Current liabilities include all these 10 accounts, right? That's going to go a long way in defeating any disputes later, or
I
avoiding disputes
agree.
later.
I think my number one piece of advice or my takeaway would be when it comes to drafting the contract, take your time. Take your time, be very specific, and include illustrative examples because it will potentially save you a lot of heartache down the road if you're very clear on what is or is not included.
Yep. Yep. Okay. Do we have any other questions?
No, I don't think we have any current questions in the Q&A, so we could go to the next slide, which is key takeaways. Peter,
Okay. So key takeaways. Post-acquisition disputes are driven primarily by contractual language. When I say contractual language, again, it's ambiguous, vague, omitted language that's not there. It's not accounting theory. So that's number one. And that's really what I think drives most of these things because you have an agreement that's not perfect. Um, so working capital disputes, they're typically mechanical, but they're highly sensitive to definitions and consistency requirements. Remember that there are judgments. There are, it's accounting is not black and white. That's what I tell people. There are so many judgments that go into every single account. So you talk about accounts receivable, right? Well, accounts receivable have a thing called bad debt reserve, have a bad debt reserve associated with accounts receivable. Well, the bad debt reserve is based on management's judgment. How much should we set aside for bad debts? Well, that requires, some thought of, well, what do we think, with respect to what receivables are collectible, which receivables are not collectible, what's our historic level, and there's all these different types of adjustments that go into that when you're determining that actual account value. So it involves all these judgments. And so working capital, yes, it's a mechanical calculation, but there's so much judgment that goes into every one of these accounts. It's really helpful, again, to have an example of what you mean. Um, Earnout disputes really arise from misaligned incentives and I would say lack of operational constraints on the buyer. Because what happens when the buyer takes over the company, I mean, they're incentivized, obviously, to not pay as much, they don't want to pay any more for the company. And so they're sort of incentivized not to pay the earnout in some respects. It depends, again, is the seller still actively involved in the business or not? But bottom line is the buyer still takes control of the company and still can make operational decisions of the company. And those operational decisions are necessarily going to impact the earnout. In reps and warranties disputes, they often turn on financial misstatements. So again, it's arguments that things were not prepared in accordance with GAAP, disclosure gaps, or fraud considerations. If you had a situation where the seller repped, let's say that they didn't have with respect to certain contracts, or let's even assume a legal dispute, or they were being sued for something, and that was not properly disclosed as part of the deal, then you really do, I think, have a serious reps and warranties issue. But if you're using reps and warranties as just another mechanism to get a purchase price adjustment, I don't find that those things succeed very often. The next one is, forensic accountants may assist with various types of disputes. Well, we've talked about it. I mean, forensic accountants can assist before the deal. Forensic accountants certainly assist post-deal where they're either representing the party or assisting the party in resolving the dispute or actually serving as a neutral arbitrator themselves. Um, and then ambiguity and omissions in the purchase agreement really do kind of fall to the experts because if it says, financial statements are going to be prepared in accordance with GAAP. Well, what is GAAP? Well, we better get an expert in here and explain what it is and how you're supposed to do that. So that's how they help. And then the last key, which I think we've been harping on this whole time, is just well-drafted agreements can prevent disputes. And again, if you really want to have an agreement that is bulletproof and at least as bulletproof as you can make it to not have a dispute, put an example in the back of the agreement as to how you're doing the calculation with respect to working capital and earnout, and use real numbers. So take numbers from the company's financial statements, plug them into an example and show this is how we're going to do the working capital true up. This is how we're going to calculate the earnout. And if you have that amount of specificity there, you're probably not going to have a dispute that goes to litigation. So that's
we're happy to take questions from the audience if there are any. Please feel free to use the Q&A function. We will be happy to assist. Peter, let's just talk for a minute about GAAP. Because for the attorneys in the room, they may not be familiar with what GAAP is, and it may come as a surprise to them that it often is not. GAAP can often be principles based. It's more conceptual as opposed to providing mechanical definitions for how you calculate something. So for instance, Peter gave a great example a minute ago when he was talking about an allowance for uncollectible accounts, right? So GAAP basically says that it's a best practice to establish an allowance for uncollectible accounts for people that you think people that aren't going to pay, basically, right? And there is a spectrum of different ways to calculate that, and it can vary based on judgment, based on past practice. So for instance, there could be a scenario where the company says, if anything's over 120 days old, we're going to reserve all of that. Other people might say, no, I'm going to do 180 days. Other people might go on literally like a customer by customer basis and assess the likelihood that that customer is going to pay. So as you can imagine, and I just gave 3 different examples, you can get very different results depending on which you think is appropriate. GAAP does not tell you anything over 180 days you have to reserve for. It doesn't say anything over 120. It basically says, using management's best evidence, what do you think is a reasonable amount to reserve for? And so this is a perfect example where including an illustrative example saying, well, historically, we've done anything over 120 days could really help to mitigate some of the risk that it will pop up later in a dispute. Peter, there are quite a few things that are actually subject to estimates, reserves, inventory valuation, the list goes on and on. Honestly, actually, if you were to look at a company's balance sheet, aside from maybe cash, you'd be surprised. There are very few items on there that are really not subject to some degree of uncertainty and estimates.
Yeah, I agree. So we have another one. The case that we're working on is it's a company that manufactures fairly simple products, and the issue is the inventory reserve. So you're supposed to have a reserve for excess and obsolete inventory. Question becomes how much? And so the buyer's position is we're going to write off 100% of everything that hasn't moved for 6 months. Seller's position is, wait a minute, this stuff's not perishable. They continue to have value. So this is a company that makes customized products for customers. And so when they make customized products, they have to have a certain amount of excess, certain amount of leftover inventory when they do a custom run, because that customer is typically going to call up and ask for additional units. Hey, we need some replacements. Hey, we need some new stuff. And they need to keep stuff on the shelf. Now, if you just have some arbitrary way of coming up with an inventory reserve that says anything that hasn't sold in 6 months, you're writing off inventory, in my view, there that still has some net realizable value. And this is an issue that's causing, a $30 million dispute between the parties. And again, could have been avoided if during the deal, the parties had more definition around how things were going to be accounted and, what's the policy for establishing an inventory reserve.
Yeah, Peter, and we've had a couple items come in through the Q&A, so I'll read off the first one. Okay, can you speak to indebtedness and working capital definitions? How to distinguish between short-term payables versus longer-term debt? And
Yep.
let's just stop and answer that one because there's a second part to it as well.
Yep. Well, you want to take it or you want me to take it?
Define it carefully and include examples would be my
Okay.
my
Well,
Peter.
yeah, so indebtedness. So typically, let's talk about indebtedness. So we've got loans, right? And let's assume we've got a mortgage and then we have a credit line at the bank, okay? So the credit line, a lot of times, I'm going to say that this credit line needs to be brought to zero every year. So you need to pay it off, bring it to zero every year. So that is going to meet the definition of a current liability. So a current liability is what obligations do I have to coming up that are going to be due and payable within the next year? So,
Mhm.
so that meet the total balance on a credit line that has to be brought to zero is going to be the total amount of whatever's outstanding. That's the current liability. But now let's take a 30-year mortgage. Okay, 30-year mortgage. In the next year, I only have to make, let's say, 12 payments, monthly payments on my mortgage. So what you do is you take the current portion of long-term debt is current, so is the current liability. So it's only those 12 payments that you would include as a current liability. So 30-year mortgage, let's just say, is year one. My first year payments are going to be current liability. 29 additional, the 29 years that I owe coming up down the line, that is long-term debt. That is not a current liability. So hopefully that makes sense there.
Yeah, and then as Peter, so that's a good example, right? Because that's an interesting point where so that in that 30-year mortgage, if you were to look at the company's balance sheet, there'll be two different entries for it. There'll be the current portion of the mortgage, which is what's due and payable in the next 12 months. And then there's the long-term portion of that debt, which is years 2 through 30, right? Okay, and then Peter, there was a second part to this question as well. How to address prepaid amounts from services or deposits made for future performance?
Yep. Yeah. So prepaids. So
Like a
let's
retainer, perhaps, or
yeah, retainer or another prepaid. Most businesses have, let's say, insurance. So I'm gonna put I get my insurance bill. It's good for a whole year. I'm gonna put that I'm gonna pay that whole year up front, right? I'm gonna pay my insurance up front, but it's good for a whole year. So essentially what happens is that that current portion, so this month's expense for insurance, you're going to recommend, say let's just make it easy. It's $1,200, okay? So initially I'm going to put $1,200 as a prepaid asset. That's a current liability, current asset on the balance sheet for $1,200 because I paid my insurance. Now, after month one, I'm going to essentially amortize that prepaid. So it's $100 a month. What happens is I'm going to expense $100, and hopefully I'm not losing you guys, but I'm going to expense $100 after month one. So my prepaid balance after month one is going to be $1,100. It's not going to be $1,200, okay? So I got 11 months remaining. And so you're going to do that every month until you whittle down that prepaid balance to zero over the course of the year. And hopefully that makes sense to the person who asked the question.
And then Peter, we have another question as well. Do you have experience with disputes arising under reps and warranties insurance policies that you could share? So I think the short answer would be yes, we've seen it. And in fact, I think we've actually seen an uptick recently and probably claims being submitted. Whether or not the claim is accepted is a different question entirely.
Well, my apologize to anybody who sells this insurance out there who may be on the line, but I think that there's an uptick in the amount of reps and warranties insurance that's being sold. Okay. But in my experience, I have never seen, and I'm just a sample of one. Okay. So, but I've talked to people in this field as well. It's very difficult to get the carriers to pay on this. Okay. It just is. So Maybe if you have a clear situation where, again, let's assume as seller repped that they didn't have any lawsuits, and all of a sudden a lawsuit turned up, and it was was filed way before the deal closed and everything else. So you got really good facts. Yeah, I think maybe there's some insurance that can be collected there. But a lot of times there's shades of gray. We've got a case right now where parties are trying to collect on reps and warranties insurance. It involves inventory. And the carrier has all kinds of arguments to say, and they're using the same arguments that we heard before. Well, wait a minute, you had a working capital true up, should have been covered there. We're not, this isn't fraud, this isn't reps and warranties. Should have been happened in the normal course with the working capital true up. And so I haven't seen. I mean, I've never seen it. Every deal I've ever seen, there's always a denial letter in the file. Okay, so the first thing, you make a claim against the carrier, and there's going to be a denial letter, at least initially, that hey, we're not covering this claim. That's my experience.
I think that's probably many people's experience with this matter, right? And then it's just, try again and see if you get a different result the next time.
Now, maybe down the line you get some negotiation and you get some coverage, but it's not. I don't think it's a safe harbor for these deals in any way. That's just my own opinion.
So Peter, we are at time. We're at 1:30, which I believe means that many people probably need to get to their next appointment. But there are still 2 questions left in the Q&A. I'm game if you are.
Yeah,
to
let's
finish.
Yeah.
Okay. All right. So there's one question, which is, this is kind of an interesting one. What is the pre-closing consulting work that a firm like yours can help with a limited budget and a small deal of under $500,000 sale of assets? Or is that just too small to care about?
Well, I mean, it's tough, right? Because when you deal with professional rates and you're dealing with a deal that's a $500,000 deal, your consultants can cost a lot of money, and really, you should probably save your money and not hire them. But if you're talking about a really like a shoestring budget, right? What I would recommend is you would always say take a walk down the balance sheet. Okay, so what's on the balance sheet, and what do those amounts look like? What do those assets look like? What do those liabilities look like? And then go and see, well, what are the policies and procedures with respect to how you've been accounting for revenue, for instance, and then look at things that are easy to clean up, like adjustments to earnings that are non-recurring, right? So let's say you had some major repairs that you had to do to a building or something like that. That's going to be non-recurring. You're going to want to make sure that that's not reflected in your go-forward earnings. If you have a bunch of stuff in there related to owner compensation, I would try to take those out. That's going to boost your earnings and make the business more attractive and those types of things. But I would say bottom line, for a $500,000 deal, you are not going to get a lot of firms such as ours to want to sign up for that just because it doesn't pencil out from a cost benefit perspective.
And I agree. Okay. And then, so Peter, the last question, could you share some of your experience with price allocation, goodwill, and intangible assets valuations? Oh, those are potentially some of the more complex items to that. So price allocation, goodwill, and intangible assets valuations.
Yeah, well, I mean, listen, we deal with those things, but typically those things are not in the context of post-acquisition dispute. So we're not dealing with things such as goodwill. It's not a current, it's not a current item on the balance sheet. So we're not dealing with that as part of post-acquisition. But we do deal with that as part of our commercial dispute practice, right? And so we do have to deal with things such as that when company A is suing company B over IP related issues or anything like that. I mean, that's the normal course. And when we're doing valuation, we typically use the 3 primary steps, which would be we usually look at cash, right? So discounted cash flow, we look at comps, look at the market, and then we look at asset approach. So those are the 3 methods that we use when we're doing that. Is there another piece of that question that I missed, Christina?
I don't believe so. Just could you share some of your experience with price allocation, goodwill, and intangible assets valuations?
Yeah. Well, let me deal with price allocation. We have another case where we're dealing with price allocation. Okay. Price allocation or purchase price allocation, okay, is it's an art and it's a science, okay? It's a situation where you got different stakeholders at the table. And there's different motivations for those stakeholders at the table, okay? The buyer of the company needs to take the purchase price that they paid for the company and then assign it based on fair value to the assets and the liabilities of the company, right? And if there's excess value there, they create something called goodwill. But there are all kinds of tax implications associated with that, okay? There are depreciation and amortization issues associated with what values you assign to certain assets, equipment, any type of asset. How you depreciate that is going to determine your earnings of the company going forward. And usually the other person that's in the room or lurking thereabouts is going to be the external auditor, and they're going to have to come in and they're going to audit those price allocations, okay? And so they're going to have to get satisfied that those price allocations were done in accordance with GAAP, okay? So you got all these sort of competing motivations there. And I can tell you as someone who's been a fly on the wall in the room when they're doing this, it's kind of some horse trading, to be honest with you. It's not a exact science. It's, how much can we do here to get everybody assigned to these assets and these liabilities because we've got tax motivations and all these other things I just described. It's not black and white. There are shades of gray all over the place when you're doing price allocations.
Okay, well, I believe that was the last question from the Q&A. So, Peter, I think we could go ahead and wrap up.
Yeah. Well, thank you very much, everybody. Really appreciated your time. I hope you learned something here. We certainly have enjoyed the opportunity to speak to you today. Thank you very much.
Thank you.